The next case is Christopher A. Scala, etc. versus William A. Scala et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument, if that applies here. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
May it please the court, Marion Little and Orville Reed, on behalf of the appellant, I'd like to reserve 3 minutes for my rebuttal. We're once again before the court seeking relief from a trial court decision that summarily dismissed a breach of fiduciary duty claim brought by Chris Scala. The defendant's defense in the lower court's decision turns on whether the controlling shareholders admitted unequal treatment of Chris can be legally justified as a legitimate business purpose, and if so, whether there's an issue of fact meriting a jury trial. I would submit that the proffered business purpose identified by the trial court and defendant, one, is a matter of law not sufficient, and two, if it were, issues of fact abound in this matter. A legitimate business purpose, as the title suggests, necessarily focuses on the interest of the business, not the personal interest of the shareholders, or the desire to solidify their control or reduce the control or interest of the minority shareholder. Now, the defendants argued below that the business necessity or legitimate business purpose here was the necessity to avoid a hypothetical corporate deadlock. That was the only thing they offered. And I'll ask you the rhetorical question, and I'll provide the answer in a moment. But if the business necessity was to avoid a deadlock, and that's the only reason you needed to structure the transaction in this fashion, why was it that my client didn't receive majority control? Because if he had, then there wouldn't have been a deadlock. That's not what happened. My client did not receive 51% control. In fact, the defendant in this case, Bill, did not receive 51% control. He took 66% control. And as this court knows from its prior decision, 66% was the golden standard, because not only did you have control economically, but you had absolute control because that gave you the ability under the shareholder agreement to act unilaterally. And we know that this all occurred without Bill giving any consideration to the litany of other means available, both as a matter of practice and under the law, for avoiding a deadlock. We know that you could have had a proxy. We know you could have had a shareholder agreement. We know you could have an arbitration provision. The record abounds with examples of these many different ways you can avoid a deadlock.
Counsel, is the less harmful means part of the Crosby standard?
It is, Your Honor, because, and necessarily, I know that there is a dispute about the parties about when that comes into the analysis, but the legitimate business purpose analysis, whether we look at it from the lens of how the Massachusetts court approached it, or we look about it in terms of how the Ohio Supreme Court approached it, which I would suggest is indistinguishable, but if you take the argument advanced by my opponent, you necessarily have to decide whether there was a legitimate business purpose. And when you look at the legitimate business purpose, wouldn't you necessarily look to see whether there was a less restrictive means for securing that result? The answer, of course, is yes. And that didn't happen in this case. So we're back to the rhetorical question, answer to the rhetorical question. The interest here that was being served by this structured arrangement wasn't for the benefit of the corporation, which is necessarily the purpose of having that exception in the first place.
Counsel, let's just hypothetically say that the interest of preventing a deadlock is sincere and is at what's issue in this case. Is that a significant business interest?
I would suggest to you it is not. It's not as a matter of law, because there is, in the corporate world, we can have 50% shareholders all the time. The revised code makes a provision on how to resolve deadlocks. But the fact that you have an interest in gaining control cannot in itself be a legitimate business purpose, because now we're starting to alter what is the basic fundamental right of a shareholder.
But counsel, in this instance, we're talking about a closely held corporation, right? Isn't there always going to be some sort of personal interest of all shareholders?
Well, you got to draw a distinction between, well, in a closed corporation context, Your Honor, of course, every shareholder has an interest, and that's what Crosby made clear. Every shareholder's interest is entitled to protection. Everyone's entitled to have an equal opportunity. That's what the emphasis of Crosby is. I mean, there's been a suggestion, both in the prior argument for this court, that sort of Crosby is kind of this, well, it's kind of a procedural issue. It's not procedural. This is a substance issue that actually has meaning. Because when we think of closed corporation context, naturally, those are the situations where you're going to see these type of breach of fiduciary duty cases. Why? Because of the Crosby decision. It says there's a heightened fiduciary duty. And we often see it in the context of a family dispute. Why? Because family members are often the shareholders in a closed corporation. But what's significant about Crosby, and we're really not looking at this with a clean slate, because there's so many Ohio cases dealing with this in this context, whether it's brother versus brother, sister against brother. We've seen it in a host of contexts. Sometimes it's the wife against husband when there's a divorce situation. But Crosby has made clear, as through the subsequent appellate court decisions, that there has to be equal treatment. There has to be equal opportunity. And yes, everyone has a vested interest in their own personal shares. And you, of course, in the normal context, might want to take more. You might want to leverage the situation. But what you can't do that is with a disrespect of the minority shareholder's interest. There, in fact, this is not simply lip service, but when you look at the results in the Ohio cases, the courts have said we mean what we say. This has to be appropriate treatment. And so when we look, and again, answering that hypothetical question, for whose benefit was this? It was for Bill's.
Counsel, I don't want to cut you off from answering Judge Sutton's question, so when you're finished, I want to ask you a question.
Sure. And it was done to ensure both his power and control. That is the quintessential example of a breach of fiduciary duty under Ohio law, Your Honor.
Well, I just wanted to get back to some of the things, the foundation of this appeal to begin with, maybe. And my understanding is the foundation of the appeal is that they shouldn't even been allowed to get a second bite at the apple.
And I'm sorry, who should not have a second bite?
Well, we sent it back to the trial court.
Oh.
I was the author judge. We sent it back to the trial court, and the trial court gave them an opportunity to do summary judgment over again.
That certainly was an error, Your Honor. As we pointed out in one of the footnotes, that when a case is remanded for further proceedings, it necessarily assumes that there's an issue of fact and requires the jury's consideration of those issues. And we certainly made that argument to the trial court that there's no reason to revisit this. The trial court initially agreed with us and denied their leave to file a second motion, but then a motion for reconsideration was filed, and lo and behold, that was promptly granted, and we're back in the soup again. Mm-hmm. But I certainly agree with Your Honor that we thought the court's instructions were clear.
Well, I didn't say what the instructions were. I'm just asking, I thought that was one of the foundational things that you were arguing, that they should never have been able to do that. Now, maybe I misunderstood your briefs.
Well, we are in agreement. We have simply focused more on the substantive merits, Your Honor. we certainly did observe in the briefs some of the issues associated with the peculiar way in which the trial court reconsidered this matter.
Thank you.
So, so we have the quintessential example of a breach of fiduciary duty, and so I want to turn back again to this concept of legitimate business purpose, because that concept presupposes that the court found there was a violation in the first place, which that's the case here. That is, if you accept the facts as described by this court and its prior decision, what has happened here is an oppression of the minority's interest, a denial of the minority's rights. And so it's only after you reach that threshold would you even consider whether there's a legitimate business purpose defense available. And I say defense because it is a defense. It's not the burden of the plaintiff to establish that there was a legitimate business purpose, but rather as in every other aspect of Ohio law when you're dealing with a fiduciary, where the fiduciary's actions are challenged, whether it is the maintenance of dollars, that is the escrowing of funds, for example, or the fairness of a related party transaction. It is always the burden of the fiduciary to establish that there is a defense. And the trial court, of course, jumps over that in this case. But let's be clear, the defense, the burden, in every respect, fell on the defendants in this case. Then addressing Judge Sutton's question more specifically, can the fact that someone wants to simply take control and avoid a supposed deadlock, can that serve as a legitimate business purpose under Ohio law? I would submit to the court's decision what we cited in the brief, the Bonds versus Miller decision, where the First District observed that disenfranchising a shareholder to perpetuate one's own control is not the kind of legitimate business purpose envisioned by Crosby. And again, it goes back to the point, particularly in a closed corporation context, a 50-50 structure is not atypical. It is a common situation. And more fundamentally, we know that this is a disputed fact. Judge Sutton, you said, if assuming that this was a benevolent intent, there's no benevolent intent established in the record here. There is at best, and I say at best for the defendants, conflicted record, with affidavits and deposition transcripts going both ways. What you have in a situation in this one where we're talking about a hypothetical deadlock is because Chris had never taken any action to create a deadlock. Chris, as you see in the record, was passive. I'm sorry, Your Honor.
You're running into your rebuttal time, just want to let you know that.
Thank you. I'll sit down and conclude my remarks after counsel. Thank you.
Thank you, Your Honors. Do you mind if I put a timer right here?
Sure.
Thanks. May it please the court, my name is Matthew Nacon and I represent appellees Bill Scala and the estate of Michael Scala. I intend to focus my time here today on the first assignment affair, which it appears is what the court wants to be hearing about, unless the panel has any further inquiries.
I have a question.
I had a feeling you may.
So in paragraph 35 of our last opinion, there was nothing that we said that reversed the court for another summary judgment motion. We just said there was an issue of fact.
Actually, Your Honor, I don't believe that this court ever said there was an issue of fact to be decided. In fact, what I believe the court did with respect to the reversal was solely under whether there were issues of law because the court applied the wrong standard of law.
Counsel, in paragraph 35 it says, a provision can be adopted pursuant to the terms of an agreement and nonetheless violate a fiduciary duty.
Correct. And that
Which we said the trial court was wrong.
And that was wrong in the application of the law because as the court will, certainly Judge Carty wrote the opinion, what the court said in that case was it is simply because you perform these tasks pursuant to a contractual right does not mean you are insulated from a claim of breach of fiduciary duty.
In paragraph 36, we say the trial court additionally relied upon the business judgment rule. So it seems like we're saying two different things here apply.
You are. Two different errors of law. One error of law on the determination that a contract in and of itself, a contractual right to do something, cannot amount to a breach of fiduciary duty. And then the second one is being that the court applied the business judgment rule when it should have applied Crosby versus Bean to the facts that it had found. This court may also recall, because Judge, you wrote it, again, on a motion for reconsideration. And
Yes, I've looked at that motion for reconsideration.
I imagine you would have, and we asked the court to apply the facts that were, at that point, unchallenged, and certainly the court had not found any fact to be improper, and this court said, that's not for us to do. Send it back, presenting it back to the trial court.
But an argument can be made. In ruling on that motion consideration, we were merely replying to your arguments. And your argument was that we should go ahead and do this. And we said, no, that's not how the Court of Appeals works. So I don't know, can you use a motion for reconsideration for law of the case? Because that's really the only place that that's indicated.
Your Honor, we're not challenging the law of the case. We're not here to argue that because there was a contractual right to modify the agreement, that in and of itself can't give rise to a breach of fiduciary duty. It's under what circumstances, and that kicks you into Crosby. We're not challenging the law of the case when it comes to whether the business judgment rule is applicable here, because this court was very clear, it applies to directors and it doesn't apply to shareholders. What we are pointing the court to, and I believe Judge Sutton, you were involved in the case, is the case of King versus Devine. And in that case, the court made an error of law in ruling on a dispositive motion, and this court ruled that when it goes back down to the trial court, because the court applied the wrong law, then the court is to reconsider the motion at the time and apply the correct statement of law, which is exactly what the trial court did when we moved it to do so. So yes, Your Honor, when this came back down from the Ohio Supreme Court after it refused to expand Crosby twice, the court had never analyzed this case or the facts that at that point which were not in legitimate dispute under Crosby versus Bean. It was required to do that, which is exactly what it did on summary judgment, and found that the exact same facts that it applied the business judgment rule to also applied to exonerate the defendants from any claim of breach of fiduciary duty with respect to Crosby versus Bean. Judge Sutton, to address the issue you raised also as to whether or not the least harmful means is any part of the Crosby analysis, it absolutely is not. Least harmful means comes from a 50-year-old Massachusetts decision. It is not a doctrine that is cited anywhere in Ohio law. It has not been adopted in the state of Ohio, and it is no part of Crosby to begin with. Just as are none of the other things that have been suggested here, like the court may recall the first time around, the appellants argued that the business judgment rule plays no role in this case. Interestingly, in their merit brief, they want to drag in the business judgment rule to argue that under the business judgment rule you can't, for a disinterested director, and they even miscite the standard, but for a disinterested director, you are not free from the business judgment rule doesn't apply if you have a self-interest. The Crosby analysis, absolutely 100% in the syllabus, contemplates the exercise of self-interest. And it is after that, in fact, it uses the exact words, a shareholder that is acting or acts for their own benefit, the elements that still must be proven by the minority shareholder are that there is not equal treatment of the action taken, which would be the Second and Third Amendment, and that there's no legitimate business purpose. If I can address this issue about a hypothetical deadline, that is plainly ridiculous. You are faced with a situation where 5 shareholders entered into an agreement in 1990. They provided for provisions under which it could be amended, and you are now down to 3 shareholders, and there was nothing hypothetical about Michael having significant health issues. There was nothing contrived about that because Michael is not here any longer. He had serious health issues and realized that if he died, that we are going to be faced with two shareholders with 50% interest and an agreement that has no mechanism to break a tie. Chris didn't have to threaten deadlock. His actions are what threatened deadlock. And these are the key facts for the court to look at with respect to whether or not there was a legitimate business purpose. First of all, I would suggest that actions taken by a majority to prevent a deadlock are per se a legitimate business purpose. However, this court need not go that far because in this case, there are substantial facts from which the court has already taken notice that justify the action here. This court recognized in Scala 1 that we had a shareholder in Chris Scala who was incapable of getting along with his siblings, that there had been significant problems in that regard, and in fact at one point Chris led an uprising to terminate Bill. It's all laid out in Scala 1. These shareholders didn't get along. You've got Michael Scala, who is now in a position where he is seriously ill, and Bill and Chris are going to be left to themselves.
Counsel, let me
Yes.
ask you too, in regard to, I want to understand the procedure here too.
Absolutely.
When we remanded the case, you requested leave to file summary judgment again.
We actually filed leave to renew our existing summary judgment.
Okay, so you didn't present any different evidence?
In the actual motion, no. We filed a very bland motion to renew the summary judgment and have the court revisit that issue.
All right. So what did you demonstrate in summary judgment on your motion that there was no issue of fact in regard to whether or not that they acted in good faith?
Right. So, Your Honor, obviously the court was taking notice of the entire record, because the entire record, which I'm certain this court understands how massive it is, all of those matters were still cited in the motion itself. So there was no new evidence from the time, there was no new evidence taken from the time of the decision in Scala 1. We immediately, when this came down from the Ohio Supreme Court, we immediately filed a motion for summary judgment. Initially, the court did not allow us to do that, contending that our rights were exhausted. We filed a motion for reconsideration based on King versus Devaki that said the court applied the wrong standard. We read the Court of Appeals decision to say, hey, when we asked them to apply the standard, go back to the trial court, we're now asking you, trial court, you don't have to do anything different on the facts, simply apply the law. Because the same law that insulated these gentlemen as directors would insulate them as shareholders, because the Crosby standard and the business judgment rule apply to two different roles, shareholder and director, but the standards are actually relatively close to one another. I think, Your Honor, it cannot be lost that Bill Scala and Michael Scala had a fiduciary obligation to the corporation in addition to its fiduciary obligation to Chris Scala. And for them to sit back and not take action when Chris refused anything for a period of 15 months, I think that needs to be understood. These gentlemen sat down and tried to work this out from October of 2015 until December of 2016, when the sale happened between Bill and Mike. They also passed the Second Amendment in January. There was no race to get this done. This was a situation where certainly we would have liked Chris to agree to something, but Chris hasn't agreed to anything in 40 years, and he wasn't agreeing to anything this time. He wanted a 50% interest. He wanted the shareholders agreement not to be amended in any fashion, and he then used that opportunity in discussions to say to Bill and Michael, if they were not going to agree to make him a 50% shareholder, then the company should simply be sold. how is that not certainly facing a legitimate problem for the corporation?
Counsel, we don't have a lot of time left, so I'd like for you to address assignment of error number 3, if you don't care.
Certainly.
And that is in regard, as you know, to the draft entry that was submitted to the court. Can you explain a little bit more about that?
Yeah, I think that's assignment of error 2. Assignment of
Oh,
error
I'm
3
sorry.
concerned a different issue.
Yes, you were right,
Yeah,
I apologize.
Yes, that's okay. But assignment of error 2 concerned the court, appellate rule 5G requires the parties to, a move-in to submit an entry generally when you file the motion. Because we didn't have leave, we asked for leave to be refiled. What the court did is issued an entry and said, counsel, when you submit your reply brief, submit a draft entry.
Counsel, that's what I want to ask you about.
Yes.
So did the court ask both sides to submit entries?
No, it asked the movement, which is what appellate rule 5G provides.
Okay, and under that rule, it doesn't require any filing, isn't that just implicit?
No, it does not require any filing, and in fact, I believe the purpose of appellate rule 5G, or of the rule 5G, is that it doesn't become a statement of the court. You can submit what you want in support of your motion, but it doesn't become anything for the court until the court puts its signature on it and adopts it. There's no, in fact, we sought to file it. We asked the court, do you want these filed? And the court said no, submit them by email, and the court will make its determination as to what it intends to do. Your Honor, the bottom line is it becomes the ruling of the court when the court makes its ruling. The first time around, which obviously was a different trial judge, so there's been 2 judges that have awarded summary judgment on this case, but a different trial judge. Again, all entries were submitted by email for that trial judge as well. In that case, the plaintiffs Chris asked for an opportunity to respond to ours, because in that time it was filed at the time the motion was filed, again by email. Chris did respond to it, which was another entry. When Chris asked after the reply brief was filed for leave, and this is no issue before the court, it just happens to be procedural, the court denied a subsequent surreply after the brief, after the reply brief, expecting that what it was going to get from Chris when he asked for the opportunity to file his own judgment, or his own proposed entry, which I don't think the court would have needed any help if its intent was to say, motion denied, which is what Chris would have suggested. Nevertheless, I'm not suggesting what we argued to the court was he was looking for an opportunity to file a surreply, and that's what he would have used that purpose.
So when you submitted it to the magistrate
Yes,
via email,
yes.
you did give a copy to the other side?
Oh, absolutely, of course. Always. No communications with the court without everybody receiving it, yes. Which was the exact procedure in Scala 1. And quite frankly, it's the procedure of the Medina County Court of Common Pleas. Your Honor, if I could address one further issue, and I'm really short on time. An issue on res judicata. Res judicata, we believe, bars any challenge to Mike and Bill, under the first assignment of error in Scala 1. They briefed the issue, they drafted the assignment of error, they lost it, they didn't appeal it. It is there. If you read both, I'd encourage the court to read the reply brief, in particular in Scala 1. They attack the court's, what they regard as findings of fact. They lost the issue. It was res judicata when they did not appeal that to the Supreme Court, just as this court held last week in the I believe it was the Dressier case last week, Judge Carr, where you issued a dissent, but your dissent was that the facts of that case only should have been
That was a suppression motion.
I don't know that it was I believe that, well, I might be naming the case wrong, the
No,
dissent.
but my point is, there had to be findings of fact. In summary judgment, there are not findings of fact.
No, Your Honor.
Okay.
The case I'm referring to is a case that was in the federal court system first.
But it was on a summary judgment. No.
It was on a summary
It was summary
judgment
judgment,
motion.
that's right.
And it was on a
Pertaining to a
summary-
motion to suppress.
Correct, and it was a summary judgment motion again in the court the second time around. And what the court did is say these issues were decided in the Court of Appeals. I'm sorry,
I
these
hate to
issues were
interrupt you, but
decided.
you're well over your time, so you have to wrap up in about 10 seconds.
I will
And
do
it's
that.
my fault, I
Yes.
apologize.
That's okay. Judge Sutton, I believe you wrote for the majority that those facts that were already decided in the federal court are collateral estoppel and res judicata, and the case is over. Thank you very much. We urge affirmance of the Medina County Court of Common Pleas.
You have about 2.5 minutes on rebuttal.
The defendants may have written the trial court's decisions, but it certainly did not write this court's decision. Contrary to what counsel has suggested, there was no determination by this court that the facts were undisputed in considering the breach of fiduciary duty claim. In fact, when the court considered the first issue, which is what counsel just referenced, it was only in the context of the argument did the trial court make an error in relying upon a prior determination relating to a discovery issue. The court concluded that it did not. That was the sum and substance of that issue. There's no res judicata that attaches because there's been no factual issue that has been determined as it relates to issue 2. And on issue 2, the court was clear, I submit, contrary to their efforts to try to rewrite the court's decision, like it did for the trial court, that this matter simply was to be sent and retried. Now, with respect to the entry, I just can't pass up the opportunity to make a comment on it. An entry is usually a one-page document that says a motion is granted or denied. But what they've submitted in this case is, in each case, extensive reasoned decisions to try to justify, where they quite frankly compounded the same errors that had been committed the first time around. One of the criticisms we have of the trial court's supposed decision is that it simply takes the same arguments that this court previously rejected, reframes them, and then applies them again. So they double down on the same mistakes. And by the way, this is from the same people that say, yes, we object to having these made part of the public record. Under superintendent's rule of the courts, those should have been filed. When we submit entries in courts, we submit them as attached to the motion. Proposed entry is attached. That's how you make a submission to the court. But not only did they oppose that, not only did they not do that, when we said that that should be made part of the public record so that this court has the benefit of seeing what's occurring before the trial court, they opposed that. So for them to suggest that that's what they wanted to do is simply untrue. They also suggested that once this case was remanded to the trial court then applied the law. Think about that for a moment, because one of the law propositions they're simply ignoring is Rule 56. Counsel's offered you a description of what he thinks the facts are. Those facts are not true. So saith Chris in his sworn testimony. This is not a case.
Counsel, in our motion for reconsideration, we did have a line that said that appellate courts don't look at an issue for the first time on appeal.
That much is true. What was true for the trial court, though, is that it should not be in the process of weighing evidence. And so they simply offered you a presentation now that you know from your review of the record is contradicted. Chris simply was not bought out by his brother because his brother did not want to comply with the shareholder agreement. So when it comes to the issue of whether a less restrictive means should be considered, well, considered in this context, Judge Sutton, it goes to pretext, if nothing else. Is there a sincere interest to avoid a deadlock, or is it a power grab? Well, when you don't apply the less restrictive means possible, you've established the pretext that there was never a sincere interest to avoid a deadlock, that from day one has been the case, and what was recited in the testimony, that there have been for decades an effort by Chris to gain control of a company that his father said the children should share it equally.
And you're well over your rebuttal time, so
Thank
if you
you,
could
Your
wrap up in about 15 minutes, or 15 seconds, excuse me.
He's done.
You're done, all right. You both had a couple extra minutes there.
Thank you.
Thank you, Your Honor.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you again.
Thank you.